Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Shannon Bell, a Colorado construction lien law expert. Today's webinar topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous and wonderful Shannon Bell.
Well, thank you so much. I appreciate that introduction. We are going to be going through what you do after the lien is filed. I'm also going to touch upon, I'll just give you a little preview of what we're going to cover today, some of your other options, because the lien is not a guarantee to get payment, and there are other things to consider. Just as a quick reminder on this webinar, if you do have any questions today, please go ahead and use that chat box on the right. We will answer any questions at the end of the presentation today. Please, however, do not include any specific information regarding names of individuals or company names in the questions. Keep it anonymous. And if you think of a question and you did not have an opportunity to get that answer today, go ahead and email us and we will circle back and try to help you out with that. So again, just giving you a bit of a roadmap of what we're going to cover today on the lien foreclosure, what a bond substitution does, and we're going to talk a little bit about both bonds, payment bonds versus a bond substitution, remind you of those contract provisions that may be available to you, and at the end, we're going to give you some of the wonderful resources that are available to you from SunRay. So let's jump right in. We're talking about pursuing lien rights. There's a couple of presentations that SunRay has available to you as well on protecting your lien, getting that lien recorded. So what we're talking about today, we're not going to go through the nuances of creating your lien, protecting your lien. What we're talking about today is moving forward to be paid on that lien. And so for this presentation, this is assuming that you have a perfected mechanics lien, meaning it is timely, it was recorded, and you've done all the right parties have been named. That's not good enough. So you have that lien, it is sitting there in a clerk, it's in the county of where the real property where you performed work is situated, but that's not going to get you paid. The next step is to foreclose that lien. What does that mean? That is initiating a lawsuit to force the sale of the property so that you can be paid through your lien rights. Just like your mechanics lien has some pretty tight and specific statutory deadlines associated with giving notice and recording that lien, there are also tight deadlines and specific deadlines to foreclosing, i.e. initiating that lawsuit to get paid on that lien. In Colorado, a mechanics lien claimant must bring that foreclosure action within 6 months after one of the 3 dates. The date the last work was performed, the date the last materials furnished, or the date of completion of the building or improvement. And so these are to the project as a whole, not necessarily specific to your individual work. Something else so you want to be watching that project. Who are you on the project? If you are, let's say, the one of the framers, you may have be doing work earlier in the project. If you're doing some of the finishing touches, you're at the end of the project. So that 6 months is going to be a lot shorter for you if you're doing work at the end of the project versus someone who's doing work earlier in the project. We want to be paying attention to the status of that project. And if in doubt, file that lien foreclosure action. By filing the lien foreclosure action, you're going to protect that statute of limitations, and you can always stay it if there's. We're going to talk about arbitration, but that's one reason to stay the lien foreclosure. Or if maybe the owner's like, look, I'm going to get this completed, I need to get some sales, and then I'll have the funds. But you don't want to sit back and wait for that and let those lien rights go by. So again, pay attention to those deadlines. make sure you initiate that lien foreclosure action within the statutory timeline. The failure to do so can invalidate that lien. I've given you the Colorado deadlines. These are state specific. So if you are looking at a lien foreclosure in a different state, make sure to work with your local counsel to assure that you have the right deadlines calendared and that you do not miss that. So once you initiate that lien foreclosure, you don't have to limit it to a lien foreclosure. You want to make sure that you are asserting that foreclosure right, that claim in the complaint, but you can also put in there your alternative claims. 99% of the time, a lien foreclosure is accompanied by a breach of contract. You haven't been paid, and the lien is just one method of protecting yourself to get paid. The company that hired you or the entity that hired you, unless they have a good faith basis, such as defective work perhaps, or maybe there was delay, they're the entity that owes you the money. The lien is just securing your interest in getting paid by locking up that main asset, which is the property. So if you're doing that lien foreclosure, go ahead and put in breach of contract. When you're doing that lien foreclosure, do make sure to name any and all parties which may have an interest in the property. The best way to do that is to work with the title company to pull an ownership and encumbrance report on the property. Oftentimes these are only, some companies will do it for $5, $10, $15. Sometimes it's several $100s, but it is money well spent to assure that you're naming all the proper parties, because one of the things that will happen in a lien foreclosure is a determination of who has priority. In other words, not to get too deep into the lien foreclosure process, but the party who, you're basically having to take out or satisfy people who have a prior interest in the real property. If it is work that is performed for construction of new property, typically the mechanics lien holders are they get a jump to the front of the line, and they will hold a first interest over any and all other deeds or recorded interests. If it is construction, like a remodel, the lien is going to be helpful because you're encumbering that real property. However, you may be second in line to a mortgage, which is secured by a deed of trust. So these are things to be aware of in the lien foreclosure process as to kind of where you sit in that line of priority and how beneficial that lien foreclosure is going to be versus just a straight up breach of contract lawsuit. The other thing I want to just point out real quickly is if there is a project where you have several contractors or subcontractors, material suppliers, none of whom are getting paid, once one initiates a lien foreclosure, everyone else can assert their rights in that foreclosure matter, and that's going to protect that statute of limitations. It's going to go back, it's going to be deemed effective for everybody who enters into the case the date of that the first complaint was filed. Mentioned to you impact of arbitration. Something that comes up a lot in construction contracts, and you may have this in contracts in projects you're working on now, is an arbitration clause. And you've seen these, you know what these are. It says, in the event of any dispute, the parties agree to submit any and all disputes to arbitration at the American Arbitration Association in conjunction with the AAA rules. So you're doing work on a project, you're owed a lot of money, the owner hasn't paid you, you record your lien, you initiate a lien foreclosure, and the owner goes, you have arbitration. We don't agree to be in court. We're going to insist that this goes to arbitration. They're probably right. that if you have that contract clause, that those breach type of claims, those failure to pay type of claims are subject to arbitration. However, lien foreclosure is a statutory right that generally only a court can grant. So what do? You're paying attention to me. You're going, well, hold on. Shannon just told me that I only have 6 months to foreclose this lawsuit or to foreclose the lien. Project was completed on January 1. I need to get my lien foreclosure done by June 1. And in May 1, I filed the lawsuit, but they're saying it has to go to arbitration. Well, what do? Well, what you do there is you still file that lien foreclosure, and then you can stay the lien foreclosure. There is a significant amount of case law that says the proper method is to initiate the lien foreclosure and then move to stay that lien foreclosure action in district court pending resolution of the arbitration. So yes, you are in essence doing two parallel actions at the same time, but you're going to stop and stay that lien foreclosure pretty soon in the process. And courts generally must grant that stay. But again, kind of depending on jurisdiction, I know in Colorado there's some really good case law discussing that that's what the court needs to do. That way you've protected your rights, you're timely on your lien foreclosure, but now you can still go into arbitration and you have not waived your arbitration rights by initiating that claim, so long as everyone acts pretty quickly in moving it to arbitration. Now you may be saying, okay, well, this seems really inefficient. So I have to do a lien foreclosure action in district court. Then I have to go to arbitration. And then when arbitration's over, I'm going to have to come back to district court. Yes, that is how the process works. However, one of the things you're going to be doing in a lien foreclosure action is demonstrating to the court that the lien is perfected, meaning proper notice was given, it was recorded within the time frame to do so, the necessary parties have been named, and the amount that is requested in the lien is due and payable. The arbitration can be determinative of those issues. And then you're taking that award to the court and saying, you do not have to make a determination on all of these things. An arbitrator already did so. We just now need to get the process going of forcing the sale of the property. Now, that said, oftentimes if you go through arbitration, those issues are found in your favor. The party against whom you're trying to foreclose, or the party who's in breach of contract, the general contractor, for example, if you're a sub, they may often pay the amount that's owed, and then you do not have to go through the whole lien foreclosure action. If they don't, though, then you've got that backup protection in the real property, and then you go ahead and see through that lien foreclosure. The other thing that will often come up in a lien foreclosure, you do that notice of commencement of lien, or maybe not. Maybe you haven't even foreclosed the lien yet, but the owner goes, oh, whoosh, you're going to affect that lien. You've recorded the lien. You have not started the legal action to foreclose it, but it's still of record on the property. That's clouding title. I can't sell the property with that lien on there. And I need to sell the property to obtain revenue to pay the lien holders. So what that can happen is the owner will go to a company and they will obtain a bond, and they will bond around the lien. And I'm sure you may have seen these, and they will often, so that can happen again prior to commencing a foreclosure action, because that owner may take that bond around action once those liens are recorded. So what will happen is they can go to the court and they say, hey, court, here's the lien that's on the property. I've obtained a bond. I want the court to substitute the bond for the lien. And so long as there is a sufficient surety to allow that substitution, the court will grant it. And again, the court can do this ex parte, meaning without notice, and so you may not know that that has happened. It still, however, allows protection for you, because what that bond substitution means is that protection that you had in real property is now held in a bond. So then you still have to do the foreclosure, you still have to do it within the requisite time frame, but now you're foreclosing against the bond instead of against the property. But both are basically protections in place to allow payment. And in some ways, a bond foreclosure is easier than a lien foreclosure, but be aware of those actions and don't waive those rights by saying, oh, there's a bond out there, I don't have to foreclose on the lien anymore. The bond is really just acting in place of the lien, so all of those statutory timelines still apply. If there's a bond substituted, you're going to do a foreclosure on the bond within 6 months. If you have an arbitration claim, you're going to do a bond foreclosure within 6 months and then stay that pending conclusion of the arbitration. I just wanted to take a quick note here, not to confuse the bond substitution with a payment or performance bonds. Your payment and performance bonds, as most of you on this call probably are aware of and know, those are, depending on the dollar value of the project, they are required on public projects. They are permissive on private projects. Some private entities will do them, which are great if they do, but it's not as common. But that payment bond is another form of security that, because you cannot lien public property. So if you're doing work for a governmental entity, City and County of Denver perhaps hires you, you can't lien property owned by the City and County of Denver. The way to give you protection is to have that payment bond. Be aware of those, because similar to a lien, a bond foreclosure on a performance or payment bond is generally only 6 months after completion of the project. Some bonds may have some different language within the bond itself, but just be aware of those distinctions, in particular if you are doing work on a public project. So just another rule of thumb, if you are doing work on a public project, it is helpful and good to ask for a copy of those payment and performance bonds before you even start any work, right after that contract is signed, so you have it handy. Let's talk about some of your, I'm going to change gears on you here a little bit and going back to the contract. As you recall in the beginning, really what you're looking at in a mechanics lien foreclosure or a substituted bond foreclosure, or even on a payment bond, is a breach of a contract. It is a breach of the contract by the entity that hired you to promise to pay you for the work you performed or the materials you have supplied. And all that these liens or bonds are doing is giving you a layer of protection that if the entity that hired you, like, oops, sorry, we spent all the money, we don't have any money. Oops, sorry, we're a limited liability company. There's no one to go after because the limited liability company is defunct. These liens and bonds are giving you some protection in those types of events. But you always have your breach of contract, in particular when you do not have a defunct LLC, or if you got the money, maybe there's some issues with the owners not using those funds properly. So don't forget about going back to your contract. You have these breach of contract claims. You might not have an unjust enrichment claim, however, and for those of you unfamiliar with that concept, breach of contract's pretty obvious, right? You have a written or oral agreement to do work, you do the work, and there is a promise in that contract. You do the work, you deliver the materials, you get paid. Maybe you've worked with a contractor or subcontractor owner for lots of projects. You're comfortable with them. There is no written contract, there is no clear oral agreement, and you say, but I still did the work, and you benefited from my work. I still deliver the materials, you benefited from the materials. It would be unfair for you, the owner, for you, the contractor, whomever you are reporting to keep the value of the work or materials I provided without paying me for them. And that's the concept, the kind of the heart and soul of an unjust enrichment claim. That one party has been unjustly, unfairly benefited by someone else performing those services or supplying those materials. And that's in the absence of an express contract. Some jurisdictions, however, will not allow an unjust enrichment claim if there is a mechanics lien that's been foreclosed, or that has been recorded. So just be aware of where you're performing work if that is a claim that you can assert. If it can, it's an alternative to a breach of contract. You're generally going to assert both to protect yourself. And if they come back and say, no, this unjust enrichment claim should go away. We contracted, but we dispute it for whatever reason, then you're just in a straight contract land. If you have, speaking of contracts, if you have the benefit of being able to negotiate that contract and put terms in there, it's really helpful to put in a prevailing party clause. What that's going to do is allow for, in addition to the amount that you are owed for services or materials or labor given or performed at a project, the prevailing party clause will also give you increase that likelihood that if you have to do a lien foreclosure, if you have to do an arbitration or a complaint in district court for breach of contract, the potential that you will also be awarded your attorney's fees and costs. In the absence of a prevailing party clause, in particular on just those breach of contract claims, you have no right to recover your legal fees. So if you are owed $50,000 on a project, you do not have a prevailing party clause, and you spend $20,000 in legal fees to get paid your 50, you're really only netting 30. So that prevailing party clause can be very impactful to protect you in the event you have to pursue litigation to get paid. Something else to be aware of is whether you waived any of your rights to seek a lien foreclosure or to record a lien. Because if there is a lien waiver, it's basically a receipt that says you've been paid X amount, you've been paid X amount, and you've waived your right to lien the property. And those are enforceable. So don't just sign a document that says a lien waiver unless it is accurately reflecting the value of work you're getting paid for, because once you do, you are waiving your right to record a lien. And if you record a lien in the face of a lien waiver, you are likely paying the other side their attorney's fees and costs for recording that lien in the face of a lien waiver. So be aware of that. There are two types of waivers. I'm just going to go through these quickly and so we can have some time for questions. But the two types of, actually the kind of four general types of lien waivers. You have during construction, that's going to be a progress payment. One's going to be conditional, and then one's unconditional. So the conditional is in time. They say, okay, you've submitted a pay application for $10,000. Here's a conditional waiver and release. You will waive your lien conditioned upon payment of that $10,000. You get the $10,000, then it becomes, they'll typically then do an unconditional, saying, okay, this now acknowledges you've been paid the $10,000 and you've released it. So those are your progress payments. Those are throughout, each one of your pay applications. Then you've got your end of construction, last work is done, final pay app submitted. Again, conditional, okay, here's your final pay app with retention. in your last invoice, you're owed $50,000, you're going to waive your lien rights conditional upon receiving that $50,000. Or here's your final retention, here's your final payout, you're claiming 50, we're giving you 50, but you have to sign this unconditional waiver. Be aware of those. This is just more information on those payments that I already walked through on those conditional versus unconditional payments. Don't mean to be all doom and gloom, because this is for my clients in particular, it's very frustrating that they have to go through all this process and there is not a guarantee of payment. Because if you obtain a judgment in court or you obtain an award in arbitration, that doesn't necessarily equal guaranteed payment. Sometimes you have to chase payment. You can chase payment by doing what are called asset interrogatories, which you send to the entity that you have a judgment against to try to find out where they have those assets, where are bank accounts, any real property. Obviously, maybe not so obviously, if you have a bond foreclosure or lien foreclosure, you hopefully don't have to go through this type of collection issues because you now are collecting against the property. You're collecting against the bond. If you don't have that lien right, you don't have that bond right, you just have that judgment, you just have that arbitration award. Oftentimes, third-party collection companies are a good option for you. They're going to be less money for you than having your regular attorney handle it. And they've got some good resources available to find assets. So with that, I'd like to open it up for questions and appreciate you listening in and joining us today.
Well, Shannon, like always, you are incredible. Thank you so much for that presentation. You gave us a lot of really good information. There is a question that has come through. It says, can a lien be amended in Colorado?
Great question, yes. And I really appreciate that question because there's a couple things. A lien can be amended, and in fact, it should be amended if you have a, well, let me do it backwards. So let's say you've recorded a lien, you're owed $200,000. Well, then the owner finally pays you $50,000, so now you're only owed $150,000. Absolutely, you need to and want to amend that lien because you don't want to be accused of having an overstated lien. An overstated lien is one that is against the property for more than you know you are owed, in which case the entire lien can be invalidated. On the flip side, if you're starting to get slow pay and you're getting nervous, in February you're owed $50,000, you record a lien. You still there's a promise to pay. So you're still doing work. In March now you're owed $100,000. You can go back and amend that lien. So absolutely you can amend those liens either up or down. The other thing you can do at any time, and this does not have to be, you do not have to give notice to the owner. You can do a notice extending your ability to record a lien. That will go of record. That's not going to affect your lien foreclosure, but it's going to affect your lien recordation. And that's going to potentially buy you time towards the end of the project. So if you're doing your 4 months, you're done in the project, your work is done in January, but there's 6 months of work on that project, you're going to do that notice extending to buy you more time beyond that 4 months from when your work is completed and tying those lien rights to when the project is completed.
Okay, wonderful. And that actually leads into another question that was asked. So you stated on that answer that there was an extension that you could file for your lien extension. This person is now asking, are there any extensions you can file to extend the deadline to file the foreclosure suit?
Yeah, unfortunately, there's nothing you can record to get an extension on filing that lien foreclosure suit. That lien foreclosure suit absolutely needs to be initiated in court within 6 months of those dates we looked at. Last completion of project typically is the last date, but maybe there's some additional materials or work that's performed after the project was completed, but there is no extension there. One thing I do want to note on the lien recordation, if you're going to do that extension does need to be recorded within your 4 months of when you last
Got it.
performed
All
work
right.
or delivered materials.
Perfect. Thank you. And then one other question that came through, it says, in Colorado, can you put a lien on the tenant's interest?
Typically, no. And it depends on what it is. So if you're saying the tenant's interest, this would typically come up in a TI situation in which you're hired by the tenant to do tenant improvements. And you can do a record, you can lien the property, which is really not the tenant's interest, it's the landlord's interest. Oftentimes, landlords are going to have notices of non-lienability posted. If that is the case, then you cannot lien the property. And then there's oftentimes the landlord tenant are going to have a contractual provision against each other where the tenant has to indemnify the landlord. Because really you're liening the landlord's interest if you're performing work for the tenant.
Right. I think what they're asking is in that situation where there is something prohibiting liens being placed on the property and you're hired by the tenant, can you then lien the tenant's interest rather than the actual real property?
The tenant doesn't have an interest in real property.
So I know, like in other states, how it works is that it's the tenant's interest, meaning anything that they own on that property, and it kind of ties into then their lease on that. Is that anything similar in the state of Colorado?
I am not aware of anything like that in the state of Colorado because
Okay.
mechanics lien it's an encumbrance of the real property and who owns that real property. Whereas in Colorado, typically the tenant has no ownership interest in the real
Correct.
property. They may have personal property that they own, but a mechanics lien will not cover personal property.
Okay, perfect. Thank you so much for that clarification. I do think that that is all the questions that have come through. Like Shannon said earlier, if anybody does think of another question that wasn't addressed, please feel free to reach out, and we'll be sure to answer those questions as soon as we can. All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's some really great information available to you. And also, like what Shannon said earlier, is everything that she spoke about today is pertaining to Colorado only. Every state has its own unique lien laws, deadlines, document types. So please check out our website so that way you can help prepare yourself and make sure you know what is expected and what those deadlines are. Can you go to the next slide for us? Wonderful. Okay, if you don't mind, give us a moment to review us. We really do appreciate any feedback that you're able to provide to us. It takes about a minute of your time, so we really do appreciate that feedback, anything you can tell us. All right, and then the last slide. That's all we have for you guys today. Thank you so much to everybody who did attend. We hope to see you at our next webinar. I hope you all have a beautiful and wonderful sunny day. Thanks again, Shannon. You really are wonderful. Thanks you. Bye,
My pleasure.
guys.
Thanks, everyone.